We have finished up to, good evening to all of you. We have finished up to Article 80. Today we go to Article 81. Article 81 deals with suits filed by executors, administrators, or representatives under the Legal Representatives Suits Act. Executors, who are executors, sir? Who implement the will of the deceased. Who are the administrators? Who administer and look after and manage the estate of the deceased. And who are the representatives or legal representatives? That is the sons and daughters of the deceased. And under the Legal Representative Suits Act 1855, a suit can be filed the date of the death of the person wrong. Suppose, let us say, A is a person who is a victim and he has been wronged by some other person. Then, after his death, the executors who implement his will, the administrators who look after his estate, or the representatives who are his sons and daughters can file a suit as if they are the wronged person, and within 1 year it has to be filed. Of course, I have not come across a single suit under this particular article. Then 82 is executors, administrators, or representatives under the Indian Fatal Accidents Act 1855. Here, fatal accidents, most of you know, we are finding the accidents in railways, accidents in aircraft, accidents in various angles. That is fatal accident. Suppose a person is working in a factory or is working in an industry and he suffers injuries, and consequently to the injuries, he also dies. Then, as far as the compensation is concerned, the executors who administer the estate of the deceased, the administrators who look after the estate of the deceased, or the legal representatives, be it the sons or daughters, can initiate action within 2 years. Then 83 is under the Legal Representatives Suits Act against an executor or administrator or any other representative when the wrong complained of is done. Suppose the executor himself, the administrator himself commits a wrong or commits a mistake, then the legal representatives can bring a suit within within 2 years. Then, sir, 84. Please remember they're all of academic consumption, but in real practice they don't come into operation. Then 84 is against one who having a right to use property for specific purposes, perverts it to other purposes. That is when the perversion first becomes known to the person injured thereby. Suppose, let us say, a premises or open land is given for a particular purpose, but it is used for some other purpose, and it is used for a purpose other than for which it has been leased. Then, in that case, a suit can be brought for compensation within 2 years from the date of commission of the wrong, or when it comes to the knowledge of the person who is a representative or so. Then 85 deals with compensation for destructing a way or a water course. Here, I think this is the latest subject now in Telangana, where FTL they call it. FTL means full tank level. As far as FTLs are concerned, you cannot construct near the FTL. And if any illegal buildings come up there, it is quite open to the authorities to consider to demolish it. I think perhaps you know recently a demolition spree is going on whereby the tank beds are being encroached, and today most of the floods in the city is caused because of the tanks being encroached. Then in that case, it is said for compensation for destructing a way or a water course. Suppose, let us say, the canal passes through your field, then you divert it to your field and prevent the other people from using it. Then, within in that case, you can claim compensation and you can file a case within 3 years. Then 86 deals with compensation for diverting a water course. What do you mean by diverting a water course? This, no, I think most of you must have seen in movies as well as TV channels where water course, which has to flow through the normal course, they divert it to their field so that the other fields get parched. Then in that case, compensation can be claimed within 3 years period. Then 88 is compensation for infringing copyright or any other exclusive privilege. What do you mean by copyright? I think in this regard, I would like to cite one case which really happened in our composite Andhra Pradesh state, where what happened, there is a classic book on the law of contracts which has never matched. That is just written by Venkatesh Iyer. And this book was copied by a sitting judge of the AP High Court, Justice E.V. Venkatesham. And he copied that book, but he called it as Elements of Mercantile Law. But verbatim copying was done, and the persons who were having the copyright, the executors, brought an action for compensation. And ultimately, because this man being a high court judge, it was settled out of court, and he had to pay compensation to the person who was having the copyright. What do you exactly mean by copyright? I think perhaps in films also this is coming up now, where I think you remember there was a Telugu movie called Gorintaku, one Edurupuri Sulochana Devi initiated action against the producer of Gorintaku and said that the film was nothing but a verbatim copying of her novel, and they did not take her permission, and the copyrights were violated. Then, in that particular case, what happened was out of court settlement was reached, and the producers of Gorintaku compensated Edurupuri Sulochana with compensation. Please remember, copyright means any original work of a person, any original work which is written by a particular person, and when it has been registered under the Copyrights Act, it cannot be copied. What is called as a plagiary. Plagiary means, for example, you are now watching the Dharma Legal. Suppose, let us say, someone tries to plagiarize and take the programs which are beamed through Dharma Legal and beam it in their channel without the permission of the Dharma Legal, and Dharma Legal has obtained copyrights in respect of that, then in that case, the question is compensation can be claimed by the Dharma Legal against the persons who have violated the Copyrights Act. And compensation can be granted in that regard. Then next one is uh, to remain, to restrain waste. Please remember, sometimes, don't want to criticize our country, sir. What people do is they start, that is, to restrain waste. That is, if you go on the countryside, still it's worse. Especially if you are in Hyderabad, you go towards NFC or you go towards Rampalli, you can find the synthetic waste. You can find the what is called the sanitary napkins and all the waste material from the hospital and from the industry which are dumped there. Please remember, it gives rise to various diseases. And in that case, if the waste is accumulated at a particular place, which causes health hazards, in that case, what happens is to remove the waste, you can always bring an action within 3 years. That is when the waste begins. Please remember, once waste gets dumped, then it continues. Then you can restrain the waste being dumped into your land, and also trying to claim compensation from the opposite side, in addition to asking for injunction to prevent the waste being dumped into your site. Then 89 is for consequence, that is for compensation for injury caused by an injunction wrongfully obtained. Suppose, let us say, injunction has been obtained on imaginary grounds and injury is caused. There is no basis for that injunction. An injunction order has been taken against you. Then, if it's a wrongful injunction, you can always claim compensation. And the correct provision for that is Section 95 of the Civil Procedure Code, which says when an injunction is obtained by illegal means, then compensation can be claimed by the party. Then next one is for wrongfully taking or detaining any specific movable property lost or acquired by theft or dishonest misappropriation or conversion. That is, suppose, let us say, you misappropriate a movable property belonging to your employer, convert it into your use, and make use of it. Then, in that case, you can always claim compensation under the act, under the for wrongfully keeping the property, and 3 years period is given. I can give you one instance. When I was working in the Usman University Law College, the principal of the college, what he did was, new almaras were purchased for the library, and it had a painting LCOU, that means Law College, Usmania University. Then what this man did was, with the help of laborers, he took the almaras into his quarters and then just wiped out that LCOU, and with the new brush he got it painted as LRP. LRP means Lakshmi Kantrao Penna. Then ultimately it came to the notice of the university authorities, and what they did was they searched the house of the particular person and then seized the almaras and initiated disciplinary action against him. And also they are entitled for compensation for wrongfully retaining the property which does not belong to you, but you convert it into your own use. That is, then in that case it is punishable and compensation can be awarded. Then, sir, for wrongfully taking or injuring or wrongfully detaining any other specific movable property. It also applies to any other movable property like chairs and tables, furniture, sofa, or the chairs which are meant for the principal, or the chairs which are meant for the visitors. If you take it and use it for your own use, the compensation can be claimed within 3 years. In addition to recovery of that movable property. This is as far as part 7 is concerned, sir. We pass on to part 8. That is suits relating to trust and trust property. What do you exactly mean by trust? Trust means where an obligation is attached to the enjoyment of the property, it is called a trust. And the property which is there is called the trust property. And the person who has been entrusted with the possession of that property is called the trustee. Here, suppose the trustee commits a breach of trust or commits a violation of the terms of the trust, misappropriates the money of the trust, or converts the property of the trust to his own benefit, or converts it into for his own benefit, then in that case, what are the consequences? This chapter deals with that. Here it is said to recover possession of immovable property conveyed or bequeathed in trust and afterwards transferred by the trustee for a valuable consideration. Suppose, please remember, trustee does not become the owner. Please don't mistake that trustee becomes the owner. Trustee is only a custodian of the property which is handed over to him by a trust, and to administer it, to look after it, and not to convert it into his own use. Suppose a trustee, what he does is he converts it into his own use. You can recover possession of immovable property as well as claim compensation from that particular trustee who has committed a breach of trust, and for that a period of 12 years is mentioned within which a suit can be brought. Then 93 deals with to recover possession of movable property conveyed or bequeathed in trust and afterwards transferred by the trustee for a valuable consideration. Suppose movable property is entrusted, possession of movable property is entrusted to the trustee in trust, and he has to administer the movable property, look after the movable property, not use of the movable property for his own use, convert it into his own use, or misappropriate and commit a breach of trust. In that case, the movable property in the hands of the trustee or in the hands of the person to whom it has been transferred for consideration can be recovered within a period of 3 years. Then, sir, 94 deals with to set aside a transfer of immobile property comprised of a Hindu, Muslim, or Buddhist religion or charitable endowment made by a manager thereof for a valuable consideration. Suppose, let us say, a manager is asked to look after the charitable property or the trust property, or then let us say he sells it to someone else, then he sells it for consideration. Then the property can be recovered from the hands of the transferee who has taken the property from the trustee, and the trustee can be made liable both in civil and criminal. And for civil remedy, a 12 years period is mentioned for recovery of the property. Then, sir, 95 deals with set aside a transfer of movable property comprised of a Hindu, Muslim, or a Buddhist, religious, or charitable endowment made by a manager thereof for a valuable consideration. This is almost the extension of 94. It says, suppose a Hindu endowment, a Muslim work, or a Buddhist property, or a Christian property in the hands of the manager, he misappropriates it or sells it to some other person, a suit can be brought to recover, to set aside the transfer, and the period mentioned under 95 is within 3 years it can be brought. Then 96 deals with by a manager, Hindu, Muslim, or Buddhist, religious, or charitable endowment to recover possession of movable or immovable property comprised in the endowment which has been transferred by previous manager for a valuable consideration. అంటే వాట్ దే కాల్ ఇన్ తెలుగు ఇస్ అత్త సొమ్ము అల్లుడు దానం చేసినట్టు. Though you come into possession of a trust property, it does not mean that you are clothed with ownership rights. You have to manage and administer the property in the best way possible. But you transfer it to some other person, and some other person, it has been done by the previous manager. Whatever wrongful actions have been taken by the previous manager, that can be set right by the person who comes new. He can initiate a suit within 12 years and to recover possession of not only the movable property but also the immovable property, which is now not in the hands of the previous manager, but in the hands of a transferee to whom it has been transferred. So this finishes the 8th chapter, sir. Part 9 deals with suits relating to miscellaneous matters. So that is to enforce that 97 is preemption, whether the right is founded on law or general usage or in a special contract 1 year. When the purchaser takes under the sale sought to be impeached physical possession of the whole or part of the property sold or where the subject matter of the sale does not admit of physical possession of the whole or part of the property when the instrument of sale is registered. Sometimes what happens is you get rid of an unwanted baby. Then in that case, you can what do you mean by preemption? As far as I don't know whether they recognize it in Indian law or not, Hindu law or not, but in Muslims, the next sharer has got a right of exercising in the if the property is sought to be sold or the share is sought to be sold, then in that case the first preference has to be given to the next heir. And if he does not purchase, then only it can be sold to an outsider. But suppose the permission is not taken, a right of preemption is recognized, then in that case, if the property is transferred, the person who is entitled for the preemption right can bring a suit within 1 year to recover possession. Then 98 deals with a person against whom an order referred to in Rule 63, Rule 103 of 21 of this Code of Civil Procedure, an order under Section 28 of the Presidency Small Causes Court Act has been made to establish the right which he claims to the property comprised in the order, the date of the file. Suppose, let us say, an order has been passed in a claim petition and you have been asked to espouse that cause by way of a separate suit, then the period for which a suit has to be filed is 1 year. These are all miscellaneous provisions, please. Then 99 deals with to set aside a sale by a civil or revenue court or a sale for arrears of government revenue or for any demand recoverable on such arrears 1 year. Suppose, let us say, when the sale is confirmed or would otherwise have become final and conclusive had no suit been filed, then in that case to set aside a sale taken under the Revenue Recovery Act or any act for the time being in force to recover the government revenue, that can be set aside by initiating an action within 1 year from the date when the sale has been done. In the revenue language, it is called Dastagardan, Dastagardhan, Dastagardan, Dastagardhan. That Dastagardan means where a particular property is attached and sold for the collection of arrears of land revenue, the property vests with the government, and then it is confirmed. Then, in that case, if any irregularity or fraud has been committed, a suit can be brought to set aside that action within 1 year from the date when the property is attached or sold or recovered from a person who is the account holder who has not paid the land revenue. Then we go to Section 100 grant. To alter or set aside any decision of court of a civil court in any proceeding other than a suit or any act or order of an officer of the government in his official capacity, the date of the final decision of the court by the court on the date of this act or order of the officer or the case may be, to set aside any decision of a court in any proceeding other than a suit for any act or order of an, suppose, let us say, an officer of the court or an officer of a public authority commits a wrongful act, then let us say it has been done, it's a fait accompli. When it comes to your notice, you can always initiate action to set aside that sale or so within 1 year. Then 101 deals with what is called upon a judgment, including a foreign judgment or a foreign judgment or a recognizance. That is date of the judgment. So suppose let us say a judgment including a foreign judgment. Suppose a judgment has been made wrongly, it has you have not been made a party to that particular suit, and the judgment does not contain your name, your rights are being violated, then you can get that set aside by filing a suit within 3 years. Then 103 deals with make good out of the general estate of a disease trustee, the loss occasioned by a breach of trust. Suppose the trustee dies and the trustee commits misappropriation or a wrongful act, then whatever estate he has got, personal estate he has got, the suit can be brought by the persons who succeed to the trusteeship within 3 years. Then to next one is to establish a periodically recurring right. That is here itself when the plaintiff is first refused the enjoyment of the right 3 years. Suppose it is a period, that is what he say during the harvesting season, Kharif season or the Rabi season, water is sent from. Please remember, Telangana we don't have that much of water resources. Suppose a particular landowner supplies water to the entire people there, he cannot stop that right. Then in that case, you can say to make good, say to restore that suit can be filed within 3 years. To establish, then next one is by Hindu or for arrears of maintenance. For a Hindu, for arrears of maintenance, you've got various acts which talks about maintenance. 125 is now the new section 145 of the BNSS, where it says the maintenance arrears are there. You can always claim and you can bring a suit within. That is, it is said you can bring a suit within 3 years. But and if you go under the provisions of 125, now 145, it says only 1 year's maintenance can be claimed. But arrears of maintenance under Hindu law of adoptions and maintenance act, if any maintenance has been granted, you get the period within which a suit has to be brought is within 3 years. Then by Hindu for the arrears. Then next one is for a legacy or of a share of a residue bequeathed by a testator or for a distributive share of the property or of an intestate against an executor, then they say that if you have got any share in the legacy left behind by the deceased, you can file a suit against the executor and recover that share within 12 years. Then 107 is possession of hereditary office. Hereditary office is possessed when the properties thereof are usually received if there are no properties when the duties thereof are usually preferred. That is as far as the hereditary office is concerned, that is uh, from the father to the son, son to the Achandrarkam antadu Vamsha Paramparikinga. That is, it passes on from generation to generation. Then office is lost by you, then you can file a suit within 12 years to get that office restored. Then 108 is sued during the lifetime of Hindu or Muslim female by a Hindu or a Muslim who, if the female died at the date of instituting the suit, would be entitled to the possession of the land to have an alienation of such land made by the female declared to be void except for her life or until her remarriage. I think the Shah Banu's case also, you remember, till she gets remarried, she's entitled for maintenance. But in case without that is only the property is given to her only for her life, she cannot alienate it. If she does it, a suit can be brought to set aside the alienation within 12 years. Then 109 deals with governed by Mitaksara law to set aside the father's alienation. Suppose a father alienates an ancestral property over which you have got a right or you got a share, then within 12 years you can always file a suit and set aside that alienation if it is made by a father under the Mitaksara law governing Hindus, and within 12 years a suit can be brought to set aside the alienation. Then 110 is for a person excluded from a joint family property to enforce a right to share therein. If you are entitled to a share in a joint family property, you have been excluded, you have not been given a share, you can file a suit for partition within a period of 12 years. Please note this article, please, it's very, very important. 110, most of the people ask me a question, sir, within what time I should file a suit for partition? 12 years period is given, and please note the article, sir, it is 110. Within 12 years, you can file the suit. Then 111 is on behalf of any local authority for possession of any public street or road or any part thereof from which it has been dispossessed, of which it has been discontinued, in possession. So 30 years period is given to recover. Suppose the road is closed, some buildings come up, the buildings can be demolished, and the possession of that can be resumed, and within 30 years the suit can be brought. Then 112, sir, by any suit except a suit before the Supreme Court in the exercise of its original jurisdiction by or on behalf of the central government or any state government, including the government of Jammu and Kashmir, 3 years, that when the period of limitation would herein to run under this act against the like, please remember this, you can avoid this. Then we go to the part 10, that is suits to which there is no prescribed period. Here, suppose no period is fixed, you don't find it in any article, then 3 years period is given under Article 113. Then 114 is, suppose on the criminal side there is an appeal provided against both conviction as well as acquittal. But as far as conviction is concerned, it lies to the Sessions Court. But as far as acquittal is concerned, it lies to the Supreme Court. But please remember, before filing an appeal, you have to take leave to file an appeal against acquittal, and the permission of the prosecutor is required for that particular purpose. Then, for that, 90 days period is given before which you can file an appeal against an order of acquittal. Then, under the Code of Criminal Procedure, from a sentence of death passed by a court of session or by a high court in the exercise of the original criminal jurisdiction, from the date of sentence, 30 days period is given to file an appeal. Then sentence or any order not being an order of acquittal, the High Court to any other court. Then, sir, as far as conviction is concerned, the appeal lies to the Sessions Court. As far as acquittal is concerned, only High Court has got the power. The Sessions Court has no power, sir. Then 116 is under the Code of Civil Procedure, the High Court from any decree or order 90 days, and for the District Court it is 30 days. Please remember, most of the advocates are in a fixed within what time I should file an appeal, sir. First, look into the valuation first. Then, according to that, if it is an order from the junior court or it's an order from the senior court, subject to the pecuniary jurisdiction, if you can file it in the district court within 30 days, and if it's going to be filed in the high court, it should be within 90 days. And here, as far as the twin cities are concerned, till 35 lakhs, district courts can entertain the appeal. But after 35 lakhs, only the high court can entertain your appeals and not the district court. Then 133 deals with the Supreme Court. It is 60 days. That is in a case involving death sentence. In a case where leave to appeal was refused by the High Court, 60 days. Suppose, let us say, you seek the leave from the from the appellate court. Sir, please give me time to approach the High Court. Then it refuses leave. Then within 60 days, you can file the leave petition. But if it is to the Supreme Court, it is 90 days period that is mentioned. Then, for delivery of possession by a purchaser of immovable property at a sale in execution of a decree when the sale becomes absolute. Suppose the sale is confirmed, then you are attacking the sale by filing a claim petition under Order 21, Rule 101 or Rule 97 to 101. Then within 1 year, you have to file a suit and to challenge that. Then next one is 135 for enforcement of a decree granting a mandatory injunction. Suppose mandatory injunction is granted by the court. To enforce that mandatory injunction within 3 years, you can file an execution petition. Then 136 is for execution of any decree under other than a decree granting a mandatory injunction or order 12 years. Unless it is a mandatory injunction, a decree for mandatory injunction, any other decree, you have got a right of filing an appeal for the execution of the decree. 12 years period is given. Then the last article is 137. If no period is mentioned, no stipulated period is mentioned, then in that particular case, the residuary article 137 says within 3 years it has to be filed. So this finishes the chapter on Limitation Act. Now, the next subject which we propose to deal with is the Family Courts Act. The Family Courts Act was constituted to decide and settle all matters relating to a family, relating to the spouses, relating to the family. Here, we have got four types of. First, we'll deal with the Hindu Marriage Act. Hindu Marriage Act, please remember, the slogan is Hindu marriage is a sacrament and a Muslim marriage is a contract. And if you just try to analyze a Hindu marriage takes place between two people of different sexes, and they become one, and they get married, and they enter into a wedlock. Then what happens is there are various ceremonies which are performed as far as the Hindu marriage is concerned. I think perhaps most of you know, because most of you are Hindus, perhaps seeing it here. First, what is done is the Gauri Vratam is done. Then after that, what happens is the previous day there is an engagement function which takes place, and the boy is presented with a suiting and as well as a ring, and then next day the marriage is fixed. Then on the day of marriage, certain other rituals take place. And please remember, we Hindus, some people who profess in Arya Samaj rites, the Homam is also performed across the holy fire. Both the husband and wife invoke the blessings of Agni, and then try to ask for a boon that their marriage should be successful and there shall not be any hiccups or problems in their marital life. And there is also certain formalities which have to be fulfilled. For example, a yoke is put on the head of the girl, and the husband puts the yoke on the girl's head and takes a vow that till now we have been separate individuals. By this marriage, we become one. And then, as we till yesterday, I was a brahmachari and you are a spinster, and now we get engaged in a wedlock, and where we have to plow the field called the samsara and live together as husband and wife. Then what happens is the kanyadanam takes place. And when the kanyadanam takes place, the father of the boy first cleans the legs of the bridegroom, and then after that the Kashi Yatra is. Please remember, I'm giving you all these things before going to the Hindu Marriage Act. Then the Kashi Yatra takes place, where the boy goes in anger. He leaves the place and goes with an umbrella. Then the father of the bride comes and says, "Please don't go become a sannyasi. Please try to take my daughter as your bride." And then he performs a kanyadanam. Kanyadanam is performed when the girl sits on the lap of the father, and the father gives the girl in marriage to the bridegroom. Then the bridegroom and the bride sit in the dais, and then in Telugu customs, there is a custom that there is a screen that is put. The husband shall not see the wife, wife shall not see the husband. Then ultimately, when the court says now the screen can be removed, and then the Mangala Sutram is tied, or what is called the Tali is tied, or even there is a significance for that also. Three knots are put as far as the bride is concerned. And then the metal, that is what the girl wears it in her foot. And then after that, the Saptapati is performed across the holy fire. 7 steps are taken by the husband and wife across the holy fire, and they take oath before the Agni that in times of happiness, in times of sorrow, in times of plenty, in times of nothing, and in times of troubles, in times of plenty, all these things, they will remain together and they will not forsake each other. Then after that, Apagintolu and all these things are there. Let us not go into that aspect. But here, one thing you must remember, that a Hindu marriage is supposed to be a sacrament. And the Supreme Court also has interpreted by saying, sir, by simply trying the Mangala Sutra or the holy thread, a marriage is not completed unless the Saptapati or the husband and wife take 7 steps across the holy fire and take a oath. Then, after that, sir, the most important aspect is nuptials. Even for nuptials, also the first night, as they call it, Shovanam, as they call it in Telugu, for that an auspicious time is fixed and an auspicious day is fixed, where the husband and wife come together and perform their first night rituals. Then the marriage is over, everything is over. So, here, this is what is called a Hindu marriage, how it takes place. But you have got different kinds of marriages also, sir. Gandharva marriage, elopement marriage, then Rakshasa marriage, Muta marriage, then what is called exchange of garlands, exchange of rings, then exchange of so many things. Customary marriages are also there. And especially in the Lingayat community, there's a custom called Chira Ravika marriage. This is only performed in Chikkarpalli Venkateswara Swami temple, where the husband and where the would-be husband and wife appear before the deity, and the Purohit proclaims them as husband and wife, and then the husband, in consideration of the love and affection which he has got for the wife, presents 6 sarees, 6 petticoats, and 6 wearing apparels to the wife, and then 5 people or 10 people are fed in a feast, and then ultimately a marriage certificate is granted by the temple authorities that these people have got engaged in a marriage. Then, of course, people who cannot afford, they get married under the Arya Samaj rights. Under the Arya Samaj rights, the question is there is no restrictions. You can be a Hindu, the other person can be a Muslim, but the person who is a Muslim should claim that is called allegiance to the Hindu religion. Then, in that case, what happens is the Arya Samaj, they perform the marriage and they perform the Omam, and they proclaim the man and woman as husband and wife, and the tali is also tied, and they also issue what is called a marriage certificate. And some most of the elopement marriages, they take place in Yadgiri Gutta or the Nacharam Lakshmi Narasimha Swami temple, or Kanakadurga temple also. There also, once the marriage is performed according to these scriptures, there they also issue what is called a marriage certificate. And there are various missions also which conduct samajika pendil. That is what is called. There is one mission called Ramchandra mission. People who cannot afford, people who don't have the enough money to get married, then they go to the Sahaj Marg, and the Daji, the person who is the head of that particular ashram, he performs the marriage, and the entire expenditure is spent by the ashram people, and then a marriage certificate is also given. Why I'm trying to tell you all these things is that there is a maxim, there is a doctrine in the Hindu law called factum valet. Factum valet means even though all the formalities of marriage are not performed, law presumes certain customary marriages which take place in different communities which are prevalent or which are in vogue as on today. And those marriages are also supposed to be legal marriages. So that is the reason a Hindu marriage is supposed to be a sacrament and a Muslim marriage is supposed to be a contract. Then I come to the Muslim marriage. As far as a Muslim marriage is concerned, it is called a nikah. Nikah is a day is fixed for marriage, and then what happens is the bride doesn't see the bridegroom, the bridegroom doesn't see the bride. Then the bridegroom is made to sit, and the Holy Quran is recited, and the Qazi who performs the marriage, along with two respectable witnesses called wakils, go to the girl and then ask her, Nikah kubul hai, kubul hai. Then the girl says, kubul hai, kubul hai, kubul hai. And please remember, it's nothing but a contract, offer of marriage, acceptance of marriage. And then the Qazi also asks, have you any objection for taking so and so as your husband or as your better? She says yes. Then the Qazi comes and celebrates it and says the girl has accepted the offer and she has agreed to be the bride. Then please remember, on the day of marriage, no feast is hosted. Next day, walima takes place. Walima means a function organized, a dinner organized by the son-in-law, the bridegroom, in token of having consummated the marriage. Consummation means the marriage has been consummated. Both the husband and wife had intercourse, and the wife is satisfied about the potency of the husband, and she has no objection of taking him in marriage. And then the feast is given, and the walima dinner is hosted to people, friends and relatives, and then the marriage becomes final. So, in other words, the difference between Hindu law and English Mohammedan law is that Hindu law consummation is not compulsory, but as far as the Mohammedan law is concerned, consummation completes the marriage as far as a Muslim is concerned. Then coming to the different laws that govern the Hindus as well as the Muslims, the question is, as far as Hindus are concerned, we are governed by an enactment called the Hindu Marriage Act. Straight away, you cannot forsake your wife, or your wife cannot forsake you. There are certain conditions, there are certain restrictions that are imposed. Unless you come under those conditions, a marriage cannot be dissolved, because a marriage is supposed to be a sacrament. But as far as a Muslim is concerned, once the marriage is over, the walima is hosted, a siyanama is prepared. Siyanama is what is called the marriage certificate issued by the Qazi. One marriage certificate is given to the bride, one is given to the bridegroom, one is given to the parents of the bride, one is given to the parents of the bridegroom, and then the Jahez articles, whatever articles are given at the time of marriage, including a cot, mattress, furniture, so on and so forth, they are all called Jahez articles. But in case the marriage falls through due to various reasons, then in that case, right from the pin, you have to return it back to the opposite side. Because under the principle of restitution, once the marriage is rescinded, once the marriage is revoked, once the marriage is rescinded, then in that case, whatever articles are had and received has to be restored back to the opposite side as far as the law of contracts, law of contracts or specific relief is concerned. Then in the Siyanama itself, it will be said that the husband promises to pay for 2 dinars and 500 rupees as meher amount. That is the amount which is payable to the bride in consideration of the marriage and in consideration of the love and affection which the husband professes towards his wife. And it's a deferred amount which has to be paid at any cost, yeah, either at the time of marriage or even after that. The wife has got a right of claiming that amount from the husband. And please remember, dinar means, it is not, dinar means not 1 rupee or 2 rupees. Dinar means what is the value of gold as far as 1 dinar is concerned. Dinar is normally in the UAE and all. The value will be taken and accordingly the amount has to be paid. Suppose the husband wants to forsake his wife, then in that case, he can get the marriage dissolved by pronouncing talaq. That is, talaq is a divorce granted, a divorce given by the husband to the wife. That is 3 times talaq, 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 and then it is entered in the books of the Qazi and informed to the Waqf board, and then the marriage comes to an end. But there was a, and please remember, as far as the Mohammedans are concerned, they are given the option of taking 4 wives, and monogamy is not permissible as far as Muslims are concerned. And please remember, if the wife wants to give up her husband, she pronounces what is called kula, Khula. Kula. Kula means where the wife wants to divorce her husband, it is called kula. But once the wife gives the kula, then in that case she forsakes or she gives up the meher amount which is liable to be paid to her, and she is not entitled for maintenance also as per the Muslim law. But if you see the Shahbanu's case, there they said the Honorable Supreme Court, then presided over by Mr. Chandrachud, Justice Chandrachud, who is the father of the present Chief Justice, said that till the iddat period, there are 3 month, 3 menstrual periods, the wife has to be paid the maintenance. But the present law, which I think most probably they are given a go by to the Shahbanu's case, where they said till the date when the Muslim woman gets remarried, she is entitled for maintenance for her life. She doesn't want to get remarried, then in that case she will get her maintenance irrespective of the fact that iddat or no iddat. So, yeah, but one thing is this, there was one movie which had come on this Muslim marriage. That movie was called Nikah. In that particular thing, of course, the question is, it's a very controversial film. There they say, suppose a husband divorces his wife by talaq and then marries a second time. But he's not satisfied with his second wife, but he wants to come back to his first wife. Then, in that case, what this first wife has to do is she has to get married to some other male, and that male has to consummate the marriage, and that male has to give her up. And then, after divorcing the first husband, she can come back to the second husband, not otherwise. But the question is, most of the Muslim brethren went on strike by saying that this is a very controversial movie, it has to be banned. Of course, I don't want to go into it because some Muslim candidates are also there. I don't want to go into that controversy. Then, of course, the latest law when Modi came to power, the talaq, triple talaq has now been abolished. Now, talaq is no more recognized as far as Muslims are concerned. Then, coming to the Christian marriage, sir, Christian marriage, how it takes place is Christian marriage is normally performed in the church, and it is also in the form of an offer and acceptance. The pastor who performs the marriage, he says, he asks the bride first, are you prepared to take this man as your husband? Yes, sir. Yes, sir. Yes, sir. Then the husband is also asked, are you prepared to take this bride in marriage? Yes. Then he accepts it. Then offer plus acceptance is equal to an agreement, and that agreement becomes final, it becomes a contract. Then afterwards, the priest recites the Bible. Then after that, a feast is hosted, and then a Muslim marriage is completed. Then, as far as Christian marriage is completed. Then exchange of rings are also there. And also one more custom is, now you can kiss the bride. bride can kiss the husband can kiss the bride. These are the formalities which are followed in Christians. Then we have got the registered marriages. Registered marriages which take place before the registrar. And the registrar, you have to give notice to the registrar that the proposed bride and proposed bridegroom want to get married. They give the fill up the application form and also give their Aadhaar cards, and the respective consent of their parents are also taken, and also it's also inquired whether any divorce proceedings are there, whether the marriage is whether there was a previous marriage, whether it's subsisting or not, if the previous marriage has been dissolved, what is the decree through which it has been dissolved, all those papers you have to file. And 1 month notice is normally given and is published in the notice board, or it is pasted on the notice board. And the question is, if any no objections are received within 1 month, the registrar completes the marriage and then issues a certificate called a marriage certificate. And please remember, in 2015 or 16, now registration of marriages has become compulsory. And when you apply for a passport or when you apply for a visa, the question is the registration certificate has to be filed. Unless you file the registration certificate, your marriage will not be recognized. It will be a hazardous exercise to get the visa or get the passport. Then, of course, as far as Buddhists are concerned, I'm not well versed with a Buddhist marriage. But as far as Yadav marriage, I still remember how it takes place. In Yadav marriage, also, suppose they fix the time at 10 o'clock is the muhurtam. The marriage takes place somewhere around 4 o'clock or 5 o'clock. That's the reason I told them also better to write from 10 to 5 anytime the marriage can take place. And they be on beat of drums, and then the same customs are followed, which are followed by Hindus. Then, as far as Parsis are concerned, it is performed in their Anjuman and it is performed according to their rites. Of course, I am not well aware of the customs of the Parsis as far as marriage is concerned. And nowadays, if you want to go for a cheap marriage, then the question is get it registered and then host a party at a reception for 100 people in a hotel, give them a good feast, and then everything is over. And now please remember, now videos have come. Now those days when I was married, only photographs were existing. Now videos have come. Suppose a car is given in presentation, BMW or Mercedes Benz, or a motorbike worth about 5 lakhs is given. Please remember, they are normally kept on the platform and say that these are the things given. Now, if any vehicle is given, they hide it at a place, and so that it does not come in the video. Everything is now in video now. Please be very careful, because the question is, whenever a complaint has been made against you for dowry, those things also have to be returned. So this is the background as far as the Hindu law and the Muslim law is concerned. Now, coming to the family codes, previously what used to happen is all the reliefs under the Hindu Marriage Act, Special Marriage Act, the Muslim Marriages Act used to be dealt with by the sub court or the senior court. They were numbered as OPs. But now, after family courts have been constituted, any matter relating to a marriage, either under the Hindu marriage or the Special Marriage Act or the Christian Marriage Act or the Muslim Marriages Act, have to be filed in the family court. The civil courts have no jurisdiction as family court as far as marriage matters are concerned. Then it is numbered as FCOP. FCOP means Family Court Original Petition. And please remember, as far as the provisions of the Family Courts Act is concerned, an advocate has no direct entry as far as an advocate in the family court. He is only an amicus curiae, AMICUS space, curiae, CURAIE. That means friend of the court. He can assist the court in conducting the proceedings, but as a matter of right, he cannot have a direct audience. And all petitions that are filed, all counters that are filed, all affidavits that are filed, all petitions that are filed has to be signed by the party and not by the advocate. But if an advocate wants to have a direct entry, he must file a petition under Section 13 of the Family Courts Act for permission. The party should file a petition accompanied by an affidavit for permission to engage a legal counsel by saying that he is not versed with the legal procedure or the legal jargon. He requires legal assistance of an advocate to prosecute or defend his case. And in normal cases, permission is granted. And Of course, these are the Family Courts Act is concerned. And Family Courts Act also deals with what is called matters relating to the family. Matters relating to the family means, suppose, let us say, there are two wives for a person and he dies. And then the dispute comes, who is the legally wedded wife? Then who is entitled to the terminal benefits? Who is entitled to the gratuity? Who is entitled to the family pension? Who is entitled to the job on compassionate grounds? First wife says, I am the legally wedded wife. Second wife says, I am the legally wedded wife. This dispute can be resolved or decided by a family court alone. A civil court, you cannot file a case. That's the jurisdiction of the family court. Then all matters relating to maintenance under 125 CRPC. Now it's not 125 and the BNSS. It is now called 145 BNSS, where you can file a petition for maintenance before the uh, family court. Ordinary criminal court cannot entertain your maintenance case, or MC as it is called. And normally nowadays the rules have been enforced, whereby you say you have to file a pro forma or a specimen called the assets and liabilities of both the husband as well as the wife for the guidance of the court. Unless you file that, your MC will not be numbered. Then once these are the various pros. Then you have got the Guardian and Wards Act. Suppose, let us say, as far as Hindus are concerned or Muslims are concerned, there are natural guardians for children. As far as the Muslims are concerned, till the age of 7 years, the Muslim woman is entitled for the custody of a male child. But as far as the girls are concerned, the wife is entitled for the custody till the girl attains the age of puberty. But as far as Hindus are concerned, a Hindu father has got a right of guardianship up to 5 years as far as the male is concerned, and as far as the female is concerned, the mother naturally gets the custody, not otherwise. But even the guardian and what's that comes within the purview of the Family Courts Act, family courts, family courts, and you cannot. And of course, you've got a concurrent remedy. You can go to the district court also and file a GWOPS. It's called Guardian and What's Original Petition. Then another thing which is important is, suppose a minor's property is sought to be sold. You cannot sell it unless you take the permission of the court, and a GWOP can be filed by the guardian, expressing the reasons why the minor's property has to be sold, why it is required for the maintenance of the minor, so on and so forth. Unless the court is satisfied that genuine reasons are made out, court normally doesn't grant permission. And even if the property is sold, the sale consideration will be directed to be deposited in the court, and the court invests it in fixed deposit, and the guardian will be entitled only to receive the interest to maintain the child. Then various provisions are there, sir, which comes under the purview of the family courts. So please remember one thing, that a civil court has no jurisdiction as far as matters which are now within the purview of the family courts. But in some of the districts, like Mehboob Nagar, I've seen, you don't have a family court. If you don't have a family court, it is only the senior civil court which has got the power to entertain OPs. In Bongir also, you don't have a family court. The principal senior civil judge alone has got jurisdiction to entertain matters relating to marriage, etc., etc., etc. So this is the introduction as far as the Family Courts Act is concerned. Now we go into the purview of the first enactment called the Hindu Marriage Act. In Hindu Marriage Act, what are the important provisions? You need not go into the entire provisions, sir. Section 9. What does Section 9 says? And it is called restitution of conjugal rights, RCR. People call it very in a short form called RCR. Means where a person has been deprived, person means it includes a male as well as a female, has been deprived of conjugal company, or has been deprived of the company of her husband or company of his wife. Then in that case, you can file an OP under Section 9 of the Hindu Marriage Act for restitution of conjugal rights. You can compel the opposite side to come and live with you and resume cohabitation with you, and not to stay separately. This is what is called Section 9. In this regard, there is a leading case of the film actor Sarita versus her husband Venkata Subbaiah. The film actor Sarita filed a writ petition in the Honorable High Court of the then composite Andhra Pradesh state, questioning the legality of Section 9 of the Hindu Marriage Act as unconstitutional. She said, should compel a person to go and live with the husband with whom she has no interest or with whom she has no interest to continue or cohabitation. The court cannot compel me or the husband cannot compel me to come and stay with him. Then that case was decided by Justice P.A. Chowdhury, who held that Section 9 of the Hindu Marriage Act is unconstitutional and it is void. But the matter was canvassed in appeal before the Supreme Court. The Supreme Court set aside the judgment and said Section 9 is completely constitutional. The question is, once the marriage takes place, is the respective obligations of the spouses have to be performed at any cost, irrespective of their likes and dislikes. So Justice P.A. Chowdhury's judgment is no longer a good law. And the case on that aspect is Sarita versus Venkata Subbaiah. Then, as far as restitution of conjugal rights is concerned, that provision has been made in order to see that the husband and wife reconcile with each other, the husband and wife live together as Ram and Sita, and never forsake each other's company and perform their respective functions as a husband and wife, and at no cost they should leave each other. That is the aim and object of Section 9 of the 9 of the Hindu Marriage Act. Is it clear to you, please? Then Section 10. Section 10 deals with judicial separation. What do you mean by judicial separation? I am putting it in a very crude way. Separation from bed and roof is what is called judicial separation. Instead of breaking the marriage, instead of keeping the marriage intact, keeping the marital ties intact, and keeping the relationship intact, what the court does is they separate the man and woman and say that they must live under different roofs and different beds and not stay together. And a period of 2 years is given. I think now it is 2 years. Yes, 2 years is given for them to come together. That is not breaking the ties, but keeping it alive. Someday sense will dawn on them and they will come together. Please remember, courts are not interested in breaking the marriage. Courts are interested to see that husband and wife come together at some stage or the other, and more particularly when they beget children out of the wedlock. Here, as far as judicial separation is concerned, it is no separation at all. It's separation from bed and roof. That is called judicial separation. And judicial separation lies on various grounds. One is acts of cruelty, acts of what is called acts of adultery, so on and so forth. If you look into Section 10, you will get the various grounds that are available to you as for asking for judicial separation. It's a lesser evil than divorce. Here, but before a proceeding under the Family Courts Act takes place, there is what is called conciliation proceedings which take place. That is, both the husband and wife are called separately before the presiding officer, who tries to settle the matter through what is called advising them, counseling them to come together, not to forsake each other. And then the wife adamantly says, I am not interested in my husband, sir, let him go to dogs, I'm not bothered, I want my relief. Then the husband is asked, he also answers the same thing. Then the court tries to say, why don't you settle your matter? Why do you want to fight between yourselves? But still, if the counseling fails, then in that case, there is no other alternative than conducting a trial before the court. Then this takes place regarding everything, sir, not even restitution of conjugal rights, but also regarding judicial separation also. But here, I will be failing in my duty if I don't refer to Section 24 of the Hindu Marriage Act, which says, suppose the wife does not have means to engage an advocate, does not have enough money for her maintenance, then in that case, she can file an application under Section 24 of the Hindu Marriage Act, ask for interim maintenance and during the pendency of the proceeding, and also ask for legal expenses which she is entitled to get. Then the court, after inquiry, fixes the figure which the husband has to pay according to the order passed. I think we'll stop there because introduction I've given. I have dealt with restitution of conjugal rights. And please remember, as far as restitution of conjugal rights is concerned, it is executable under the provisions of Order 21, Rule 32. It is executable under the provisions of Order 21, Rule 32. Again, I repeat, it is executable under Order 21, Rule 32, CPC. Then the question is, sir, even I file an execution petition, I cannot compel an unwilling horse and take it to the pond when it doesn't want to drink water. Even if such an execution petition is filed, the wife does not come, or the wife is adamant she does not want to join the husband. In this regard, sir, I will try to tell you most of the matrimonial proceedings take place because of the villainy played by the mother of the girl and the mother of the boy, and they don't want the couple to live happily and together and to have their married life. Please remember they try to interfere in every sphere of activity. Please remember there is one saying in Urdu, Mia Bibi Razi hai to kya karega kazi. Then that means suppose the husband and wife have love and affection for each other. They want to stay together. They don't want to forsake each other. They want to live a happy married life. There should not be interference from either side. Sometimes panchayats are also held to see that they come together. Mediation is also held so that they come together. Sometimes social meetings are also held so that they come together. Sometimes it reaches a crescendo where both the sides adopt a cantankerous attitude. They don't want to come together. Then the only remedy is to go under the Hindu Marriage Act and ask for the appropriate remedies. And in the next class, that is tomorrow, I will discuss judicial separation in detail and also come to the next one is dissolution of marriage. That is section 12, and then 13 is divorce on various grounds. The interaction period starts, please. Any questions? Yes.
Any questions? You can go ahead. I think everybody is understood the
Sir,
class.
this is Koteshwara.
Yeah, so please go ahead.
Husband dies. He left wife and 3 daughters.
Yes, go ahead.
When to partition?
Within 12 years, you can ask for partition at any time.
Okay. Who has initiated? Is it mother or one of the child? Or?
No, not necessarily. The wife of the deceased who has got the custody of the children, she on behalf of the other sons and daughters, she can initiate action, sir.
The daughters are major, sir. They have got married.
Even if they have got majors, you have got section 29A now. As soon as a female child is born, she gets a vested right in the property as far as ancestral property is concerned. Even self-acquired properties under section 6 and section 8 of the Hindu Succession Act, she is a class 1 heir. No one can deprive her of the share. Vimala Devi's case is there. When it says it retrospective as well as prospective. Yes, next please. Sabir Pasha.
What is that case, sir? Vimala Devi?
Vimala Devi versus, I don't remember the name, but it is there, I think, 2020 Supreme Court.
Okay.
Hello, sir.
Yes.
Sir, my name is Salim. I have a doubt to Mohammedan law.
Yes.
One person married the first bridegroom, but he did not to give the divorce.
Right.
He married another girl.
Right.
But how do they claim the maintenance?
The maintenance is now the latest judgment.
Let him complete the question.
Yes, sir. Please go ahead. Please go ahead.
That person has sold that property or house already. But the girl, what did do? Claim the maintenance.
She can have a charge over that property even if it is sold, saying that she is the wife of so and so, and even if it's sold, it has been done to avoid the payment of maintenance, and she can get her share from whatever husband's share is there. She can claim a charge over the property which has been transferred.
The person is a abscond, the arrest the all address, but he cannot hear the residency.
So even if he absconds, there can be a charge on the property. She can recover it from the property.
Sir, his property already sold.
Sold means again the purchaser who becomes liable to pay.
The purchaser has a right to pay, sir.
Yes, he is liable to pay.
Any home or any property.
Yeah, whatever it is, movable or immovable, whatever it is.
Okay. Thank you.
All right. Any more questions today? Or can we conclude the class?
Yes, sir. One here, Nataraj here.
Yes.
Sir, after the death of the husband died leaving a wife and one daughter aged 14 years.
Right.
And the wife remarried. Okay. So the second husband want to change the surname of the daughter.
Hmm.
So what is the remedy? How to get it done?
You want the surname to be changed.
By the second husband's surname. They
No,
want to change it to the
he
second
can't do it.
husband's
He can't do it so long as the girl is minor.
Okay. Can you do by adoption, sir?
No. You can't even do that because she's the daughter of her own. That is the reason you can't do it. And if once she becomes elderly about 18 years, there is a chance of making herself. He can take a call on it.
Okay. Thank you. Sir, I have another doubt. There is no.
1 second. Naresh Garu, you have any doubt?
Salim, sir, I have
1 second, Salim Garu, please be in the line. Naresh Garu, do you have any doubt? Naresh Teju,
no doubts.
please unmute yourself.
Mr. Salim.
Salim, go ahead.
Sir, there is no limit to maintenance the girl in there.
I am not able to even audible to me, sir.
Just be a bit loud.
Sir, the maintenance limitation not there.
Yes.
Any mention the particular limitation act?
As far as maintenance is concerned, there is no limitation. So it comes under 125 CRPC. Now it is 145 BNSS. And now aged parents are also included there under the new act. And you can file the case from anywhere where you are. You need not go to the place where you last resided together or where your marriage was performed. That was the changes brought about by section 145 under the new BNSS.
Okay, sir. Thank you, sir.
All right. Good night. We're concluding the day for today. See you tomorrow again.
Okay.